Good afternoon, everybody. That's right. No need to adjust your screens. It's not Pete Jones. It's Andy Bobrek here, one of Pete's partners in the Labor Department at Bond here in Syracuse. It's our pleasure to welcome you again to our weekly COVID briefing. We have a really packed schedule today with an all-star lineup for you of great presenters who are going to cover a number of issues. Again, please submit your questions. We'll do our best to get to them in the course of the presentation. Again, we're pretty packed for our schedule. Want to try to keep it to 45 minutes since that's been preferred. But again, we'll do our best. And just to note too, we'll be doing some more outreach in terms of webinars and targeted webinars on specific issues. I'll mention that as we proceed through the presentation. So without further ado, I want to introduce one of my partners, Bethany Centrone. Bethany co-chairs our school district practice group. Obviously a lot going on in that area right now. Myself, as a parent, I'm following it all very closely too. And we just wanted to provide a quick update to you on where things stand. So Bethany, thank you for joining us.
You're welcome. Thanks, Andy. As many people know from reading the papers, all school districts should have had their reopening plans posted on their websites last Friday. Some may have requested an extension to update those or post those this coming Friday, but I think because of the conflicting deadlines for the Department of Health and the New York State Education Department requirements, most school districts, if not all, would have had their plans updated and posted on the 31st of July. So I think, it's recommended that, anyone who's interested, and certainly with your own children, to go to the websites, take a look at the plans. They definitely are sort of all over the map in the sense that school districts were, tried to do what was based upon the feedback that they got in their communities. Some school districts have all day for elementary schools, for in-person in different schedules. Some school districts are doing alternating days. Again, it runs the gamut, but you definitely should be looking at your school district websites to find out, how things are going to apply to your children or to your employees' children, certainly, as that's going to become more and more of an issue and more complicated as time goes on. The other thing I think that's really sort of an update, the governor spoke yesterday at a press conference and spent a decent amount of time discussing testing for COVID testing in schools. Our governor likes to speak off the cuff, I think, sometimes in relationship to those things. And as it stands now, school districts do not have the authority to require students in any event to undergo COVID testing. Certainly, if there's a concern or a reason to quarantine, then students would be subject to the 14-day quarantine or quarantine while sick with COVID. But there's no provisions in the guidance to allow for school districts to require students to take tests to come back to school or exclude them from school. And employees of school districts are basically subject to the same requirements that employees in other industries would be in relationship to COVID testing. That may be a question that comes up quite a bit, maybe something that you're thinking about, since the governor says that parents are thinking about it. But right now, unless there's additional executive orders, your school districts can't test the kids involuntarily. So it would be up to you as a parent to decide whether you wanted to do that. Really no other updates since the last time I spoke. There's been no new executive orders that apply to schools. The guidance has been stable for all of 2 weeks. So we're just waiting to see what the governor's going to do. He's supposed to announce by the end of this week whether schools are going to open. We're still far under the threshold for that to happen, which is 5%. We're still around 1%, I think, generally speaking, in the state of COVID positive testing. And school districts are waiting to see whether their plans are going to be approved or rejected. And that's going to take, I'm sure, at least a little while for the governor's office and the NYSED to get through those. 5 minutes.
Great, thanks, Bethany. Appreciate that update. From the sounds of it, stay tuned, I guess, to see what comes out of the governor's office. It's amazing how quickly this summer is going by. here we are in August, and it's going to be time for school before too long. So thanks for that, and folks, will continue to report on this issue and be back in touch with you. Our next presenter is another one of my partners in our Garden City office, Jessica Mahler. Jessica is going to talk about some leave issues in general under the Families First Coronavirus Act, as well as a decision that came out of federal court in the Southern District, which is down in the New York City area yesterday, that you may have seen in the media, and give some insight on that decision too and its impact potentially here. So Jessica, thanks for joining us today.
Thanks, Andy. So, one of the big issues, obviously, that we've all been encountering, whether it be, in our professional dealings with employees, or even, dealing with, our children and whether or not schools are going to be open, of course, is as Bethany indicated, whether or not schools are going to be open come September, and if they are going to be open, what is that going to look like, and how is that going to impact us either as employees or us as employers, managing these types of situations where our employees might have some childcare related needs when schools potentially reopen in some form. And so, one of the big questions that we've been getting from a lot of our clients is, how are we going to be able to handle this when our employees come to us and say, well, I can't come to work today, or I can't come to work tomorrow, or I can't come to work whenever the case may be, because my children are going to be home because their school is operating, either it's closed to in-person operations, or it's operating under one of these hybrid models where there's a combination of in-person schooling and distance learning. And so how do we manage that? What are our obligations? And particularly, how does that impact employees who are requesting leave, the paid leave under the FFCRA, that federal legislation? And so, we're all familiar at this point with reason number 5 under the federal legislation that does enable employees of covered employers to get a certain amount of paid time off if they're not able to work or work remotely because their children's school is closed as a result of the pandemic, or because childcare is unavailable as a result of the pandemic. And so if you have a school that is now operating in some capacity for in-person schooling, what does that mean with regard to there being a school closure for purposes of the FFCRA? And, the way that we've been looking at this is, if the school is closed in person for in-person instruction, of course, that is really going to be no different than it was in the spring. And the implication of the FFCRA reason number 5, school closure leave, would apply just the same. But it does get a little bit tricky where you're operating under this hybrid model, where you do have some in-person operation or some virtual schooling going on together. And so, I'll say, one of the big issues is, does that trigger the school closure leave under the FFCRA? And I think that the distinction is going to really come down to whether it's the school who is instructing the students that they are doing distance learning on these particular days or for these weeks, or if it's something that the parent or the families are opting to engage in distance learning, even though it's not being required by the school. And so, I think where you have a situation where distance learning is being required by the school, then I do believe you're going to have implication of the FFCRA leave coming into play in those contexts, just the same as you would if the school was entirely virtual. However, where you have situations where the parents have the option of doing virtual distance learning for their children, or sending their children in for in-person instruction, you know, I think there's some question of whether that actually would constitute a school closure sufficient to trigger the leave requirements under the FFCRA, and that would apply both for the paid sick leave portion and also for the extended FMLA portion. And so, you know, I think we are going to, or I'll say, I think it's likely that we're going to see some more guidance coming from the Department of Labor to deal with some of these questions of, you know, how the FFCRA leave might apply in the school reopening, you know, particularly the hybrid model type context. Hopefully we do get that guidance, you know, sooner than later. But I do expect some of the questions to be answered when that comes out. One of the other issues that, you know, I've gotten a lot of questions on and we've seen a lot of, you know, concern about is if the FFCRA leave is triggered, you know, come September, if schools are still closed to in-person instruction to some degree, then how do we handle situations where our employees are asking to use that leave on an intermittent basis? And, you know, I will say before yesterday, my answer to that question would have been a bit clearer. I would say that the guidance was a bit clearer in terms of how you needed to handle intermittent use of FFCRA leave. And yesterday, a court decision was handed down, however, that makes it a bit more uncertain. And so before yesterday, and I'll talk a little bit about the implications of the court decision in a moment, but just to set the groundwork, before yesterday, it was very clear under the Department of Labor's regulations and Department of Labor's guidance that essentially the only time you were able to use leave on an intermittent basis under the FFCRA was where you have the situation where schools were closed, the childcare need due to school closures or childcare unavailability qualifying event. But the guidance also was very clear that the only way for an employee to be able to use the leave on an intermittent basis was with the employer's agreement. And so it was something that both employee and employer had to agree to. Now, that's been called into question somewhat by this court decision that was issued yesterday and Andy referred to. What ended up happening was New York State, several months ago, going back, I believe, to April, had actually sued the Federal Department of Labor, alleging that various aspects of the Department of Labor's implementing regulations were unlawful. They exceeded the department's authority to issue these types of rulings. And that litigation, you know, pursued over the next few months. And yesterday, a federal court in the Southern District of New York issued its ruling, its formal decision on that litigation. And one of there was essentially four issues that the court dealt with, but one of the significant issues that the court dealt with was this issue of intermittent leave. And could the Department of Labor say intermittent leave could only be used on where you had an employer agreeing to have the employee use the leave on an intermittent basis. And so the court went through its analysis and answered that question by actually saying, in this particular situation, the Department of Labor exceeded its authority in requiring employer agreement to intermittent leave use. And so it now does open up this possibility that an employee may be able to use leave on an intermittent basis at his or her own sole option, regardless of whether or not the employer agrees. And I say it opens up this possibility, because that's what the court said. However, the Department of Labor has not yet actually changed its guidance. And for example, I checked this morning, a few minutes actually before we came onto the webinar today, and the Department of Labor's guidance continues to say that you can use intermittent leave only where both employee and employer agree. And so now we have some conflict here between what the court is saying, what the regulation said, and what the guidance is saying in terms of how this situation plays out. And so there is a bit of uncertainty, you know, in terms of which is the right answer for this. And so, you know, I do expect that over the next few days, you know, over the next week, you know, over the next few days, we will get some clearer answers to this question, whether it be by an appeal being filed by the Department of Labor to seek a reversal of the court's decision, or further guidance or further regulations being issued by the Department of Labor. So I do expect, you know, over the next few days, we'll see where some of these questions shake out, and we'll have a little bit more certainty, you know, in this sort of uncertain situation that we're in at the moment. So that was one of the issues that came out from the decision yesterday. One of the other big issues that was addressed in the decision issued by the court involved the healthcare provider exemption. Now I know, you know, many of you may have encountered this exemption, but essentially there was a provision in the FFCRA that enabled covered employers to exempt out from coverage so any of their employees that fit within the definition of a healthcare provider. Now, what the definition of healthcare provider was interpreted and written out by the Department of Labor as a very, very, very broad definition, and essentially encompassed, you know, everybody under the sun in various healthcare related operations and vendors that supported healthcare operations. The court came down, you know, and actually said that definition that was issued by the Department of Labor was too broad and covered too many people for the exemption. And so now it's now created a bit of uncertainty of, well, if that definition is too broad, then what definition do we apply? And who qualifies as a healthcare provider for purposes of this exemption? And so again, you know, there's a lot of uncertainty here, but you know, hopefully in the next few days, we'll get a little bit more clarity, whether it be from an appeal or, you know, some further guidance being issued by the Department of Labor. I will just briefly mention there were two other issues addressed by the court decision, one dealing with some documentation issues and one dealing with whether leave is available for somebody even in a situation where you don't have work available for that employee to do. And so, you know, I don't want to, you know, take up too much time. So I just sort of put those two issues out there, letting you know that they are things that came up. So if you do encounter any of these situations, employees' requests for leave, you know, that deal with any of these issues, I would encourage you to, you know, give your attorney a call, whether it be your attorney at Bond or other, give that individual a call so that you're able to really walk through with them the extent to which this decision does impact or potentially impact your own situation. So with that, Andy, I'll turn it back to you.
Great. Thanks, Jessica. A lot there to try to unpack quickly. Just want to assure our attendees here today, our clients and friends of the firm, we'll be putting out an information memo on this decision. We're getting a lot of questions, Jessica, about what is the impact of this decision? Where does it apply? Is it across the country? Is it only in one region? And I will throw that back to you. And I guess am I understanding correctly that if a client finds itself in a situation where it's dealing with an intermittent leave, potential need for an intermittent leave, if there's a documentation question, if they have a healthcare provider who they're considering to be exempt from the leave requirements, or if they're having a request from an employee who's not actively working or on layoff, those are the situations that the red flag should go up and the client should seek counsel for the time being. Is that right?
Exactly. Those are the 4 big issues.
All right, great. Thank you. We appreciate it. And I'll just mention too, there's obviously a lot going on with these leave issues currently. I expect these issues will continue to arise and perhaps with greater frequency as students, higher education students, return to communities and to schools, and of course as attendance or at least instruction resumes in primary and secondary schools. So we're going to be doing a pop-up webinar next week specifically targeted at this issue. You should get an invitation to that and obviously encourage you to attend that as well. So amidst all of the current COVID issues that, of course, we know you're dealing with on a regular basis, New York also passed a piece of legislation as part of the budget process, creating a generalized paid sick leave benefit that New York employers must follow. And there's a lot to this. We're not going to be able to cover it all today. Again, we'll have more specific outreach on this moving forward, but we wanted to give Teresa Rusnak an opportunity to speak about this issue, give you a little bit of background. If it's not on your radar screen already, it should be. Teresa, thanks for joining us.
Thanks, Andy, and good afternoon, everyone. As Andy mentioned, I'm going to be discussing a broad overview of the New York State paid sick leave law. I'll start off with an introduction to the law, some basics, such as accrual, carryover, and use, what I like to call the big 3 when it comes to paid sick leave. I'll then touch on some special considerations, such as existing leave policies and collective bargaining agreements, as well as what you do with this law as it interacts with other paid sick leave laws and unpaid sick leave laws that we've seen throughout the years. And then finally, I'll touch on a couple of documentation requests. So the New York paid sick leave law, as Andy said, it was passed as part of the 2021 state budget back in April. You could be forgiven for missing it, given that New York was in the height of the pandemic when this was passed. It's modeled after the New York City Sick and Safe Time Act. For those of you that are familiar with that, this is going to look quite similar. But for those of you that aren't, employees under the paid sick leave law begin to accrue paid sick leave on September 30th. So we're a little less than 8 weeks away from that accrual date beginning, which is why we're discussing it today. Employees, however, can't begin to use their accrued paid sick leave until January 1st of 2021. Hopefully, we will see some more guidance on the nuances of paid sick leave as we go forward. Right now, all we're relying on is the actual statute itself. Unfortunately, I think with COVID and everything else that's been going on at the state, the Department of Labor just hasn't had the opportunity to get that guidance out as quickly as we would have hoped. So for now, I can tell you the following. The leave applies to all types of employees, full-time, part-time, seasonal, temporary, per diem, anyone that works for you. It's a very broad definition of employee. The law applies to all private employers, regardless of size, though we will talk about how size impacts the amount and type of leave in just a minute. New York State paid sick leave does not apply to public employers or governmental agencies, at least as far as we can tell at this time. Paid sick leave is divided based on the size and income of the employer. So if you have 4 or fewer employees and less than $1 million in net income for the previous tax year, your paid sick leave is actually not paid, it's unpaid sick leave. If you have 4 employees and more than $1 million in the past year in net income, as well as between 5 and 99 employees, you're going to be in the second category. And then there's a third category for employers with 100 or more employees. For purposes of determining the number of employees, you need to look to the prior calendar year, and that's set forth in the statute. Accruals, as I mentioned, they begin on September 30th, 2020. Leave accrues at a rate of 1 hour of leave for every 30 hours worked by the employee. Up to a maximum of 40 hours can be accrued for the first 2 categories. For the first category of less than 4 employees and less than $1 million in net income, it's 40 hours of unpaid sick leave. For the other employees and up to 5, and for employers with up to 5 to 99 employees, that's 40 hours of paid sick leave. And for those who have over 100 employees, that's up to 56 hours of paid sick leave. Employers do have an option to front load the leave, and they may do that on a calendar year basis, or as the law provides, any set 12-month period. Carryover is the next important part of this leave that I think needs to be recognized. Employees are allowed to carry over up to the maximum accrual of their leave. So if employees can accrue up to 40 hours of paid or unpaid sick leave, that's how much they must be allowed to carry over. If it's an employer with 100 or more employees, they must be allowed to carry over 56 hours of paid sick leave. There are some questions that hopefully the guidance will clear up as to whether an employee who carries over 40 hours or 56 hours of paid sick leave continues to accrue it in the new year, or if they don't start to accrue it again until they've used some of that leave. So that's just an example of one of the open questions that we have with paid sick leave, although there are several. Use is the next of the big 3 bullet points for paid sick leave. Use for the leave, it can be used, as far as we know, as soon as it's earned. There's currently no restrictions on when the use can be. However, there are specific enumerated uses for how the leave can be used. So as you would expect with sick leave, it can be used for the illness or treatment, diagnosis, care of the employee or an employee's family member. A family member and child and parent are all defined under the law, although illness, treatment, diagnosis, health condition are not. So hopefully the guidance will give us some more clarity on what those terms specifically mean. They can either be very broad or very narrow, depending on the definitions we eventually get. Paid sick leave, although it doesn't sound like it necessarily from the title, can also be taken where an employee or an employee's family member is the victim of domestic violence, a family offense, a sexual offense, stalking, or human trafficking. And then within that category, the law sets forth 7 specific enumerated purposes for the leave related to those categories. Employers may set increments for the minimum use of leave, but they can't be more than 4 hours. So you can't say to your employees, you can use paid sick leave, but you have to use it in increments of 5 hours or longer. That's not going to work. It has to be 4 hours or less for your minimum increments. Employers can't require the disclosure of confidential information and make that contingent upon getting the leave. There is an open question right now as to what type of documentation, if any, employers are entitled to or required to get before allowing an employee to take their paid sick leave. Turning now to some of the more special considerations that I mentioned at the beginning. If you have an existing paid time off or sick leave or even vacation leave or some kind of paid leave that might fulfill the requirements of the paid sick law, there is an option to modify that policy so that it meets the carryover use and accrual requirements of the paid sick leave law. Of course, there are some ambiguities within that. So if you're looking at modifying an existing policy, please think about reaching out to your attorney for consultation on that. For collective bargaining agreements, the law does briefly address how paid sick leave is supposed to interact with collective bargaining agreements. It does not do so with any great clarity. So if you're looking at integrating paid sick leave into a collective bargaining agreement or wondering if your current collective bargaining agreement satisfies the requirements of the law, that's something I'd also encourage you to reach out to your attorney about. I just can't cover that in this length of a presentation in any great specificity. Other sick leave laws, as we've been talking about, we have a number of COVID-19 laws. We have other laws. We have the New York City paid sick leave law. We have FMLA. We have the New York COVID-19 law. We have paid sick leave for federal contractors. And then we have paid sick leave in other states and cities throughout the country. Each and every one of those is going to interact a little bit differently with New York State's new paid sick leave law. So to the extent any of those apply to you when you're looking at drafting or modifying a paid sick leave policy, you're also going to want to pay attention to how those other policies are impacted, if at all. Documentation and policy concerns. Currently, there's no requirement that an employer adopt a paid sick leave policy. That's different than what we've seen in some other laws that New York has passed recently, where they've explicitly required a policy adoption. But most employers will and should draft policies to explain paid sick leave to their employees and their supervisors. If you're going to draft a policy, some things you should consider are how the policy is going to affect use, accrual, carryover, what you're going to do about paying the leave out at termination. It's not required that it be paid out at termination. That's an employer's choice. How you're going to educate employees about what their rights are, and so on and so forth. Policies for paid sick leave should also reflect, to the extent applicable, other types of paid leave that the employer offers and unpaid leave that the employer offers, such as FMLA, contractor leave, all the other leaves that I mentioned just a minute ago. In terms of other types of documentation, the law does provide that employers must track how much leave their employees have used and accrued in the current calendar year and in any previous calendar year, so that's quite broad. The law also provides that this information must be provided upon oral or written request of the employee within 3 days of the employee's request. So I know that probably raised more questions than it answered, but that is my brief overview of paid sick leave. Again, we are hoping to get guidance on this sooner rather than later, particularly before our September 30th accrual date. And with that, I'll turn that back over to you, Andy.
Teresa, thank you for that overview. Yes, and we're getting a lot of questions on this subject as anticipated.
Sure.
This is one that we'll cover in more length with a pop-up webinar and provide more details and information to you. Teresa, one of the questions, really two questions that we're getting frequently. First is, well, what if I already have an existing PTO plan or a sick time plan? What should I do in that situation? And just so we're clear for people, I want to understand your position is, well, I think you need to evaluate that plan. You have to compare it with the requirements that are mandated under state law and see if there's any gaps there and potentially revise your policy to make sure that it complies with that. And when you do that, there's some uncertainty in the statute in terms of how exactly you do that. So work with your bond attorney or your outside legal counsel on that issue. Do I have that right?
I think that's exactly right. The first thing you need to do is look at your policy and see if it complies with the basic minimum statutory requirements for use, carryover, and accrual, and go from there.
The other question we're getting is, well, does this apply to part-time employees? Does this apply to exempt employees? And I think on the exempt employee side, I think about the tracking, right, and the record keeping that you just mentioned. Have you reviewed the statute for that issue at all? Have any insight on that issue?
I will just tell you that the law definitely applies to all employees. It applies to part-time employees. It applies to full-time employees. There's no exception for exempt employees. For them, honestly, your safest option, if you don't want to go through and track their hours, or if you don't have the mechanism for that in place, would be to front load the leave.
All right. Great. So again, more to come on this issue, folks. We just wanted to get you oriented if you haven't been already. Thanks. So next, we want to get an update from one of our regular panelists here, Kate Schmelwick. Kate's going to talk about the PPP program and just give you a quick update. Kate, thank you very much for joining us.
Thanks, Andy. All right, so I know it's been a few weeks since you've last heard from me here on the webinar about the PPP program. And in those past couple of weeks, we've received a lot of questions about the deadline for applying for forgiveness. When can someone apply for forgiveness? Questions about the 8 to 24 week covered period, which one is better or worse? So we wanted to take a couple minutes today and address some of those questions, address where the program currently stands, and then what's going to be on the horizon. So let's dive in. So first, I want to talk about really where the program stands right now, because I think that's important. So a lot of the questions we've been receiving is about when can I apply for forgiveness? And really right now, it's our understanding that many lenders are not even accepting applications for forgiveness yet. So you might be sitting here thinking, well, I want to apply for forgiveness. What's the holdup? What's going on here? So it's kind of a twofold reason. One being actually 2 weeks ago, there was guidance issued directly to lenders. And this guidance discussed really a preliminary procedure for applying for forgiveness from the lender end. So really what the process looks like is the borrower is going to apply for forgiveness to its lender, and then the lender applies to the SBA to receive the PPP funds that the SBA will then disperse to the lender to pay off the borrower's loan, or at least a portion of it, depending on if there's going to be a forgiveness reduction. So that's the basic process that the guidance had talked about when it came out. That middle step, the SBA accepting applications from the lender, is subject to a portal. And that portal is not even going to be up and running where the lender is going to have to submit to the SBA until middle of August at the earliest. And there still could be delays. We don't know what's going to happen with that. So a lot of lenders, it's our understanding, are not yet accepting applications because they can't even submit to the SBA yet. The other reason is that there's probably going to be further changes to the SBA program, whether that's legislative or through more guidance. We have been still waiting for more guidance on a few issues, and it's our understanding that the SBA is holding off on issuing that guidance until we find out what Congress is doing with further changes to the program. So last week, Monday, the Senate released the bill text of the HEALS Act, which is their new stimulus plan. And again, this is what I'm going to talk about here in the next minute or so, is not actually passed yet. It is still working its way through Congress. As of right now, both the House, the Senate, the President, Steve Mnuchin, and a bunch of others are negotiating the various terms of whatever this stimulus bill is going to ultimately look like. So we don't know what is essentially going to be passed, what form it's going to have. But some of the changes that were in the act were directly related to the PPP program. So a big change was that it simplified the forgiveness process and the documentation required to submit for forgiveness quite a bit for loans under $150,000. So again, the SBA seemingly doesn't want to issue guidance about the forgiveness process and the application process until it knows if this act passes in the current form, and is then going to really loosen up a lot of the requirements for documentation. So that's one aspect that we're keeping our eye on. For loans under $2 million, although there's still going to be some documentation required in the application, it looks like it's also going to be loosened. Not as much as the 150 threshold, but still loosened. There's also the ability to obtain a second PPP loan, and that's really limited to only certain borrowers under a certain employee threshold, which looks like right now it's about 300 employees. And then borrowers who have seen a decrease in revenue, again, under a certain threshold. So that's something else to keep in mind that's in the new HEALS Act. There's also an expansion of the program to certain entities that were not originally eligible to receive loans. So certain nonprofits are now potentially going to be eligible if the HEALS Act passes in its current form, which again, we think that there's going to be significant changes based on negotiations. And finally, there's an expansion of the types of eligible expenses that borrowers can use their PPP funds on and then submit for forgiveness. So a big subject in that is the ability to buy, so this gets confusing because it's a PPP loan, but you can buy PPE with PPP funds, so your protective personal equipment. Again, though, it hasn't passed yet, so don't start, buying that type of stuff to use your PPP funds because we don't know if that's going to stay in the final version of the bill if and when it gets passed. So with all of those changes on the horizon, we're kind of in a holding pattern right now with the SBA, releasing new guidance and going through that process. So now you might be wondering, well, now what do I do? So Right now, borrowers have 10 months from the end of their covered period to submit for forgiveness. So there's no rush. There's no application deadline that you need to be worried about at this moment to get your application in. We've been advising many clients to kind of take a wait and see approach right now, to kind of hold tight and see what the SBA comes out with, see what Congress comes out with. It may be very favorable to your business. So if you were to apply very quickly, once the applications actually open up with lenders, you may be missing out on a benefit later. So that's something to keep in mind. A lot of borrowers have been asking us, should we use the 8-week period or the 24-week period? If I'm using an 8-week period, should I submit now or wait? And it's all very dependent on your business. You've heard me say this, and you've heard Jeff Shear say this. It is very dependent on your business and what's going on. So for example, if you currently had layoffs and your business is looking better now, and even if you're using an 8-week period, if you're anticipating on making offers to have people come back or rehiring people before the end of the year, you may not want to apply for forgiveness right away, because you may be able to meet the December 31 FTE safe harbor, which would then help maximize your forgiveness. So that's a consideration, but there's also the consideration on the flip side that you've used your PPP loan, your receipts and your revenue are down so much that you have to make layoffs now or in the next couple of months. So you may actually want to submit for forgiveness sooner rather than later, before those layoffs take effect and potentially hurt your forgiveness. So there's various considerations with every business that needs to be talked through with counsel, or accountants and your team, to understand what's really going to give you the most beneficial forgiveness package. So there's definitely things to keep in mind there. And of course, as I just mentioned, we don't know what further guidance and further legislation is going to look like that may also make the process more favorable to borrowers. So that's something else to keep in mind. Another reason why it may not make sense to rush out and apply for forgiveness immediately. When choosing between the 8-week or the 24-week period, again, it's going to be very dependent. We have borrowers who've used up all of their funds, and they really didn't make reductions in their FTE counts or salaries. So it makes sense for them to apply after the 8 weeks to use the 8-week period and apply for forgiveness. For our other borrowers who didn't use all of their money in 8 weeks, it may make sense to continue to extend to 24 weeks to use up that money to then maximize for forgiveness. But again, you have to keep in mind your FTE counts and what the business is looking like with layoffs and bringing people back. So there's definitely considerations with both sides of it. Okay, so that is the current update of where we are at the PPP. I'm going to turn it back to Andy, and once we know any more information, we'll of course be either on this webinar or sending out information memos, updating everybody when we do see some changes and more guidance come out.
Thanks a lot, Kate. We appreciate that update. It's good to have. I think sometimes we start these planning for these weekly webinars over the weekend or on Monday, thinking, what are we going to talk about? And it seems every week we have more and more to fill up and for our clients to keep in mind. So we appreciate it. With that, I want to turn it over to Katie Anderson. Katie, what's going on in Albany? Nothing much these days. Is that right?
Yeah, something like that. Yeah.
Okay.
So first thing, we had a new update to the travel advisory. If we could have the next slide, that'd be great. So this slide, we look at this map. The biggest changes this week were Rhode Island was added, and Delaware and Washington, D.C. were removed. There have been quite a few questions in the chat function about this, so let me try to answer some of them right now. First thing, you're looking at, one of the questions was, if a worker goes to one of these impacted states, does the entire family have to quarantine? No. But they may have to quarantine if the Department of Health puts out an order of quarantine. That would be when they have to quarantine. But just because a member of your family goes does not mean that you automatically have to quarantine, but that person does, just baseline. Second thing is this essential worker exception still exists. It exists for healthcare workers still, so continue to look at that. And if you have other questions about that, please reach out to any of your favorite attorneys. One question that's been very interesting that popped up is that Delaware was on the list and then it was removed. So what do we do in that situation? The New York State website on this does answer this question, thankfully. So if you had a person who came back from Delaware, say on Monday, that person is still going to have to quarantine. The New York State website says, quote, provided that on the date you enter New York, such state met the criteria for requiring such quarantine, you must quarantine. Okay. So if the person comes back from Delaware tomorrow, then that they're off the list, they don't have to quarantine. But if they came back from Delaware a week ago when Delaware was on the list, they have to quarantine. It's a little bit confusing, but that's just the way we're rolling with it. Remember too, this is not retroactive. So it's as of tonight, right? It's as of 12:01 a.m. tonight that Rhode Island is effective for the quarantine. And those are just good things to remember. And so if you have other questions about that, please, reach out. We have, some other things to look at. There was an update to occupancy restrictions. And this has been the bane of a lot of our existences since May when the reopening guidance came out. In your reopening guidance, if you're, an office space, you likely have seen the language that says your maximum occupancy is restricted to 50% of the maximum occupancy as set by your certificate of occupancy. Quietly last week, Empire State Development updated their FAQs on this occupancy issue. We're going to put out an information memo on this. It's a very confusing topic, so I'm going to go over this briefly. If you have other questions about this, we'll follow up with it again next week. And this memo should be coming out, which should lay all of this out for you. First thing you have to do is, if your certificate of occupancy does not list the maximum occupancy, these are the steps you have to follow. One, you have to determine the square footage of your area. If your office space is about 10,000 feet, that's the number we're going to use today, then use that. Then you have to look at the Uniform Code's classification of the area. This is confusing. The Uniform Code is the Uniform Building Code. If you look at the next slide, I put a little bit of that code table. This is the table you're going to want to take a look at. It's table 1004. Well, 1004.5. This is only a brief portion of the table, but it tells you the function of the space and your occupant load factor. Please, I'm urging you, call your attorney to go over this with them because this is very confusing. The occupant load factor is the number of people that can fit in the space per square feet. So businesses, for example, you look at business group has an occupant load factor of 150. That means each person who's in that space needs to have 150 square feet around them. I didn't make up the numbers. I don't know why they are that way, but they are that way. A bar has like 9 feet is the occupant load factor. This changes based on your relevant classification of the area. So once you figure out what your classification is, then you have your occupant load factor. You have to divide the square footage by the relevant occupant load factor. So if you have a business that has 10,000 square feet, say it's that business group B, the occupant load factor is 150. You divide 10,000 by 150, you get 66. That's the maximum occupancy. Then you have to determine at that point what your maximum occupancy would be in halved or by whatever percentage there is in your reopening guidance. So you multiply that number by 50%. So for a business in this scenario, under these rules, the maximum occupancy cut in half would be 33 people. That was a really quick overview because we're running late. If you have other questions, please, please, please come and, give us a call. Go ahead and do that. This is hard. And please, if you have questions, feel free to reach out. We will be putting something out on this, and this is mandatory to do. Even though New York State did it quietly, they just remember to do that. You have to do this. This is part of the reopening guidance, and you have to follow it. So with that, I am done.
All right, Katie, thank you very much. I know you had a lot in there. So I guess the good news on the load factors, we got some guidance in terms of how you figure this out when your occupancy certificate doesn't say the number. And we've got a number of clients where this has come up from time to time and they're looking for guidance. That's the good news. We can now figure this out. The bad news is that it is a multi-step process that will require some judgment and analysis along the way. But it's good. But thanks for the outline of the process. I think it's a good orientation for our clients. So I know we went over a little bit today. I think it was worthwhile, though. We covered a lot of important issues. Thanks for your patience during this. Thank you for your questions. Again, we tried to answer as many as we could. If we didn't answer your question, I want to encourage you to please reach out to the panelist who presented on that topic, or to your bond attorney who you regularly work with here. Either's fine. With that, I want to thank our great all-star cast here. Thanks for sharing your information, your wisdom, and your guidance with us. And we'll wish everybody well and see you next week. Thanks.